to go through the same. So, list the matter when?
After a week, Lordship.
After a week?
Yes, Lordship.
After 1 week? Yes.
Obliged, Lordship.
None appears for the petitioner.
Yes, Lordship. Lordship, I beg to mention item number 12. Lordship, I'm for the sole respondent. If we may be given 2 weeks' time to file our vakalamnama and our affidavit in opposition.
Learned counsel for the petitioner, Mr. Such and Such present. Ms. Such and Such learned counsel submits that she has received instructions to appear on behalf of the sole respondent and seeks how much time?
2 weeks.
2 weeks time to file the vakalatnama and affidavit in opposition, if so advised. So please after 2 weeks.
There's an Indian, Lordship. There's an Indian.
The interim order passed earlier shall continue till the next date of listing.
May I please, Lordship, I beg to mention item number 18. Here, Your Lordship may kindly list this matter after 2 weeks because my senior has some personal difficulties.
Okay. You're mentioning on behalf of?
Ezimomiri.
Okay. When do you want?
After 2 weeks.
Learned counsel, Mr. Sanj, submitting on behalf of the leading counsel, Mr. A. Zimomi, please for listing the matter
After 2 weeks.
2 weeks.
Yes.
As the leading counsel has some difficulties. So, learned counsel, Mr. Sanj, appearing for the respondents, have no objection. List after 2 weeks. Yes.
Deeply obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 20 from the supplementary clause list.
Okay.
I'm yet to file my affidavit in opposition, so can they allow 2 weeks' time?
2 weeks.
Yes, Lordship.
Learned counsel, Mr. Tushitamjan Commoner, appearing for the respondent, prays for 2 weeks' time to receive
3 weeks, Lordship.
3 weeks to file affidavit in opposition. So, praise the Lord. Learned counsel for the petitioner is present. List after 3 weeks. Yes.
My please, Lordship. Lordship, I beg to mention item number 7, my Lord. If 2 weeks' time may be granted, my Lord, to file our affidavit.
How much time?
2 weeks' time, my Lord.
2 weeks.
Yes.
Learned counsel, Mr. Medovero, prays for 2 weeks' time to file affidavit on behalf of the in FA.
Yes, yes, my Lord.
It's an FA.
Yes.
You don't need to file any affidavit
Madam,
in
Madam.
FA. We'll just say to receive instructions,
Madam,
okay?
Madam.
For two weeks' time to receive instructions in the matter. Stop. Learned counsel for the petitioner, Mr. P. Pius Bata is present. So please, after 2 weeks, is brief.
Lordship, there is a stay order that must be continued.
The interim order passed earlier shall continue till the next date of listing.
Lordship,
What
furthermore,
about records?
records? We are not called. No, we may call for the records.
Anyway, we'll see on the next date. Yes, after 2 weeks.
Much obliged, Lordship. Lordship, I can beg to mention item number 17, my Lord. If this matter can come up next week, my Lord, for hearing.
Next week, with the consent of the parties, let the matter be listed next week.
Next week.
Next week. After a week. Say after a week. Yes.
Obliged, my Lord. Lordship, I can beg to mention item number 11, my Lord. Lordship, as per the office note, respondent number 1 and 2 are still awaited, my Lord. So if 2 weeks' time may be granted, my Lord.
The service of notice on respondent number 1 and 2 is still awaited. So accordingly, list the matter after 3 weeks, awaiting service on the respondents. Yes. Learned counsel for the petitioner, appellant, Mr. Medu Vera is present. Yes.
Much obliged, Lord.
Yes, Lordship. Your Lordship, I beg to mention item number 9.
Nine.
Your Lordship, we are yet to file our affidavit to the counter affidavit filed by respondent number 3 and then. So I pray that I may be granted 3 weeks.
You want to file a reply?
Yes, Your Lordship.
Okay. Learned counsel for the petitioner, Miss, I forget your name. Atsila Kips. Na?
Sigmo.
Oh, Sigmo Chang is present. And submits that she would like to file a reply to the affidavit in opposition filed by the respondents and prays for 3 weeks time. So please, after 3 weeks, is brief. Yes.
Much obliged, Lordship.
It is, my lady. I beg to mention item number 2. Here the matter is now before the cabinet, so I pray that 4 weeks time may be granted to us.
For regularization.
Yes.
Learned Counsel Ms. Vishupre, appearing for respondent number.
For all the respondents.
For all the respondents, submits that the matter is now before the cabinet for approval in order to regularize the service of the petitioners. So accordingly, she has prayed for 4 weeks.
Yes.
4 weeks time to comply with the direction of this court. So list after 4 weeks. Learned Counsel for the petitioner, Ms. Such and such is present. Yes.
Much obliged.
Yes.
Please, Your Lordship. Yeah, please, Lordship.
Lordship, I beg to mention items 16 and 21 from supplementary courses. Lordship, I'm appearing on behalf of my senior, Mr. Langnek Home. Lordship, notice upon respondents are still awaited, so if the matter could be listed after 2 weeks.
It is here.
I'm for the respondent number 1 in item number
Okay.
16.
Learned Counsel, Mr. Sajjan Such, appearing on behalf, first you write for item 16, okay? Appearing for the appellant, submits that the service report on the respondents is still awaited. So, Learned Counsel, Mr. Inti Opang appears for the respondent number 1.
1, Lordship.
So, at least after 3 weeks, awaiting service report on the respondents number
Respondent 2.
2, respondent number 2 and 3. So, and then in 18,
Lordship,
in
meantime-
21, 21 also you are appearing, isn't it?
Lordship, I'm for the respondent 1, 2, and 3.
1, 2 and 3.
Lordship.
In 21 you say Learned Counsel such and such appearing for the appellant submits that the respondents number 1, 2 and 3 are represented, however service report on the rest of the respondents is still awaited. So Mr. Intiwapang appears for respondent number 1, 2 and 3, list after 3 weeks awaiting service report on the other respondents.
Lordship, similar prayer for item 24,
Item 24.
supplementary courses.
Okay, same order, but here you say on all the respondents, is it? Yes. Service report awaited on all the respondents, list after 3 weeks. Yes.
Obliged.
His Ladyship, I beg to mention item number 14 on behalf of Mr. N. Angami. He has instruction to appear for respondent number 1. He has some difficulty today, so he asked me to pray for 4 weeks' time to obtain instruction.
Learned Counsel for the petitioner, Miss Grace Namki is present. Learned Counsel, Learned Government Advocate, Mr. K. Angami, makes a prayer on behalf of Mr. N. Angami, Learned Senior Government Advocate, who has received instructions to appear on behalf of respondent number 1 and prays for 4 weeks' time to receive instructions and to file the compliance affidavit. So, list after 4 weeks as prayed for.
Yeah, please, Your Lordship. Lordship, may I please beg to mention item number 5 and 6 on behalf of VG Momi, Your Lordship. Your Lordship, if this matter can come up after 2 weeks for filing affidavit.
Yes.
For the petitioner,
Okay.
at item number 5,
Oh, they are mentioning 5 and 6.
is representing the council for the for item number 6 as well.
Okay, both 5 and 6.
Yes, my lady.
Learned Counsel for the petitioner, Miss Such and Such is present. So, Learned PP, Miss Livika, makes a mention on behalf of the Learned PP, Mr. V.G. Momi, who is appearing in the matter, to list the matter after
After 2 weeks, Your Lordship.
2 weeks, as he would like to file an affidavit in opposition. So, list after 2 weeks as prayed for.
My
Yes.
lady, there is an interim.
Okay. The interim order passed earlier shall continue till the next date of listing.
My lady, my name has not been reflected in the course list, if it can be reflected.
You have signed in the Bakalar Nama?
Yes, my lady.
The registry is also directed to reflect the name of Miss such and such
Catherine,
as counsel for the petitioners. Yes.
much obliged.
For admission, item 1.
Yeah, please, Your Lordship. Your Lordship, the matter is still pending in the cabinet, Your Lordship.
Lordship will kindly see order dated 4/6/2026, passed by this Honorable Court.
But see, the problem is, it is now before the cabinet and it is out of the hands of the respondents. But what the respondents can do is, they can always, you know, tell the cabinet secretary to list it. Otherwise, it will never be listed before the cabinet.
Your Lordship, actually what happened is that like there was actually some development. The cabinet actually again sent back the file to the law and justice or some reference. And after that recommendation, again it was sent back to the respondent. They actually sent back the file to the cabinet, Your Lordship. So they are also persistently following the case, Your Lordship.
They should take it
Yes,
personally.
Yes, Your
Otherwise,
Lordship.
it will be just kept pending like
Yes,
that. They
Your
have to
Lordship,
take the file personally and pursue.
Yes, Your Lordship.
Lordship, this Honorable Court has now and again reiterated that matters that is placed before this Honorable Court, the Honorable Court finality does not need Cabinet's approval, or it does not have to go through the process as like any other matter in usual course. Now, last time also they took and said that it is placed before the Cabinet, and now if it goes on like this, the judgment
This is for regularization of,
Not for payment, Your
regularization, grant of scale of
Yes, scale of pay, Your Lordship.
In fact, they ought to have gotten it at the time of their appointment. But knowing the circumstances of the state financial difficulties, it has been accommodated in such a way. And now, even after the Supreme Court having dismissed the review as well as the appeal, they cannot go on like this. And the last review was dismissed on 15th January 2026. Now it is already 8 months. January, now July. And in fact, it is not my submission, it is between the court and the government that this Honorable Court
I think
Direction has been
we
disobeyed.
need to call them. We
In
need
person.
to summon them in person.
it cannot go on like this,
Your
Lordship.
Lordship, as you are well aware, Your Lordship, as far as the present respondent are concerned, Your Lordship, they have done like their part, Your Lordship, as far as they are concerned.
That
Your
cannot be a ground in
Because
contempt.
that is a
No,
procedure,
see,
Your Lordship. You're well aware of the office procedure, Your Lordship. So the matter has been put up, Your Lordship, to the cabinet, Your Lordship.
For
It has to
grant
be
of
approved.
pay scale, normally it doesn't go to the cabinet.
Your Lordship,
It can be decided at the level of AHOD and the finance department.
No, Your
actually.
Lordship, it involves a huge amount, Your Lordship, and Your Lordship, it's regarding like a central sponsor scheme, Your Lordship, and there was a dispute, Your Lordship, and but finally this Honorable Court has arrived to the conclusion that they should be given, Your Lordship. That's why, Your Lordship, we are in the process, Your Lordship. And as far as the present, they are fervently, persistently following the case, Your Lordship. And
The next-
that is the procedure, and we have put up before the cabinet, Your Lordship. So
How many of them are there? These RMSC teachers.
around 300 plus, Your Lordship.
Presently, the petitioners, it was more than 400, but some of them they resigned and they joined advertisement, and now it has come down to 367 presently before this Honorable Court.
And what about their salaries from March 2025? At one point, there was a submission that they have not been paid their salary from.
That
is
was
paid.
already paid, and it is not monthly. It is going by 2-3 months. It will be withheld, and they are still laying under such condition, Lordship. At least they could have by now. What is more to process when it is already
You take the help of the Advocate General. because to get it through the cabinet, sometimes the agendas, they never get listed. Okay.
Your Lordship, I will
So-
tell get the respondent,
Yes.
Your Lordship, that is the Commission Secretary to apprise the matter before the
To
Cabinet.
apprise
Your
the
Lordship.
Advocate General, and then because since
Yes,
he's
ma'am.
aware of the matter,
Yeah, he's aware.
and let him take personal steps.
Lordship, a direction can be given to the Commission Secretary to consult with the
No,
AG
that
to-
is up to them. They know what to do.
Yes, Your
They have to
Lordship,
know
I
what to
will-
do. You tell them.
Okay.
The learned counsel for the petitioner, Ms. Lizzie Mommy, is present. Stop, Ms. Livika, learned counsel is present for all the contemners / respondents. On 4/6/2026, the learned counsel for the respondents had informed this court that the proposal for grant of skill pay to the RMSA teachers along with their cumulative arrears had already been submitted to the cabinet for approval, to the cabinet for approval on 27/5/2026. So, and that the respondents are awaiting the outcome of the next cabinet meeting and sought some more time to get the cabinet approval. Stop, para. Today, when the matter is called, learned counsel Ms. Livika makes another prayer for extension of time, as the cabinet has not yet given its approval.
Yeah, it's still pending
Has-
before that.
As the matter is still pending before the cabinet.
Lordship,
Stop.
Lordship,
Para, yes.
it was informed that the cabinet had already said twice after
Yes.
passing of this honorable, but they are not.
No. Your Lordship, that's why I'm
No,
being.
that's why it
I
was
have
sent back to the law department
yes.
again. That's what you're saying. Why it has to be sent back to the law department?
Your Lordship-
Advocate General has already given his
Yes.
opinion.
And again, it was sent back, and they have also given that it should be given, Your Lordship. That I don't know, Your Lordship, that part. We are also feeling unfortunate.
Learned, okay, learned, what did I say last line? And learned counsel submits that in fact the cabinet had held its meeting, and the matter was had held its meeting after the order dated 4/6/2026, and in its meeting the cabinet had again decided to send back the matter to the law department for its opinion, and the said legal opinion has also been received, and the respondents are awaiting the
And the same has been actually forwarded to the cabinet again.
it
So
has
it's
been
done.
that's why and awaiting the next cabinet meeting. Stop. Para. Learned counsel therefore prays that she may be given another, how much time?
Your Lordship, now again, if I ask her, she will. But 4 weeks, Your Lordship.
Lordship,
No,
Give-
you
give
give
them
a
the-
realistic
Yes, that's why at least 4
time,
weeks.
na?
4 weeks may be gone.
And
4
we
weeks,
don't
and if
keep-
they
you have to
cannot
keep
comply,
on, keep
if
on.
they cannot comply with it, Lordship,
They
I
have
just
to come
humbly
in
pray
person,
that
yes.
let the respondent be present before this honorable court in the next listing.
List the matter after 4 weeks, na? List the matter, to list the matter after 4 weeks. Stop. The prayer is allowed. Stop. However, the respondents, especially who will be the main respondent?
Commissioner and secretary and the
State Mission Director,
State-
Your Lordship.
principal director
Specific-
and
Specifically, the respondent number.
1, 2, 3. Your Lordship.
all
three.
1, 2, 3.
All of them, or
Yes.
specifically the respondent number 1, 2, and 3 shall make all efforts to ensure that the matter is approved at the earliest. Stop. In the event that the order of this court is not complied with within the next 4 weeks, the respondents number 1, 2, and 3 shall appear before this court personally.
Your Lordship, it will be considered, let the order be like,
Lordship,
so
let
that
the-
at least I will
let
make them
the
aware
order of the
that,
court stand,
I'll make
Lordship.
them aware that
They
like on the
cannot
next
take
date, if
for granted this
No,
honor.
let
Your
them,
Lordship,
let
they
them
are
come
not
and
to this
explain
extent.
themselves, no? Let them come and explain themselves.
Yes.
1, 2, and 3 shall appear in person before this court.
Your Lordship,
And
if at least
explain
one
as
chance,
to why.
one chance may be given so that like on the next date, it will be considered.
One chance.
How
Just
many
look at
chances?
how many chances have
Of
been
course, Your
given.
Lordship, but since it
This
is a
is
procedure,
pending
we
since
are also.
2022. This petition is pending since 2022.
Yes,
Do
Your
you know
Lordship.
that?
Yes, Your Lordship.
Yes.
That I appreciate, Your Lordship.
no,
However, Your
that is
Lordship,
called-
they are also
it
making an
will become-
effort, Your Lordship. It's just that they're handicapped because of that.
No,
So at
the
least one
respondents should
chance.
know that there is urgency and that the court has been lenient enough.
At least one chance will be given so that like on the next day it will be considered for their personal appearance.
Let
Your
them
Lordship.
come and explain, and the court will see whether the delay can be condoned or not. 1, 2, and 3 to appear before this court on the next date and personally explain as to regarding the delay in the compliance of the order of this court. Stop. List on today's 13th, 14th, July, August 14th. We'll keep it on 17th, okay? 17 August. 17 August.
Highly obliged, Lordship.
Lordship, this matter is also the content petition itself is pending since 2023. More than 3 years has lapsed after I filed this content petition. And as per the last order, that is order dated 1/6/2026, it was directed that if the compliance is not shown by the respondents, this court shall consider as to whether the personal appearance of the respondent number 4 shall be necessitated. The respondents 1, 2, and 3, they are willing to comply with this honorable court's direction. It is respondent number 4, that is the BNR, which is creating hurdles in implementing this honorable court's order.
Respondent number 4 is the approval authority, Your Lordship. That's why it's taking time. It's actually under examination and
No,
so
it
far it's
cannot
still-
be under
Yes, Your
examination. It has to be for
Yes, Your
compliance.
Lordship. Yes,
They
the-
cannot
Your Lordship-
examine now at
No,
this
Your
stage.
Lordship, examination for compliance, Your Lordship. I have already submitted one lecture on the last date also.
No, basing on that letter only the
Yes,
court
Your
had
Lordship.
allowed.
Yes, Your Lordship.
My prayer at this stage, my Lord,
Also been filed on 14th. This is also regularization.
Yes, this is relating to
Here,
organization.
the petitioner, she was appointed
Contract
on,
employee,
no,
ad hoc.
on compassionate basis. However,
Compassionate, okay,
yes,
okay.
she was not appointed on regular basis, which is why we have approached this honorable court.
And the court's direction was to regularize.
Yes, yes, my Lord.
Why is this taking time? It should not, because this matter need not go
Yes,
to
Your
the
Lordship,
cabinet
I also
also.
explained to that. Your
It has to
Lordship.
be decided at
Yes,
the
Your
level of the PNR.
Yes, Your
Commissioner
Lordship, it
Secretary.
will not go to the cabinet, I believe so, Your Lordship. If they get an approval from the PNR, then automatically, Your Lordship, that is the step to be taken. However, it's still pending before the PNR, that's why we are.
My Lord, my prayer at this stage is that give them sufficient time. However, on the next step, whether it is 6 weeks, 8 weeks, it's all right. But on the next step, if the honorable court's order is not compliant, then the personal appearance
Yes,
of the respondent,
Of respondent
number 4.
4, yes.
Yes, my
In
Lord.
case within that time, if,
Yes, my Lord.
Learned counsel for the petitioner, Mr. Sentiang is present. Stop. Ms. Livika, learned counsel is present for the respondents, all the respondents,
yes, Your Lordship.
for all the respondents. Stop. Stop. By order dated 1/6/2026, this court had directed the respondents to comply with the order of this court within 4 weeks. Stop. And had also observed that if compliance is not shown by the respondents by the next date, the court should consider as to whether the personal appearance of respondent number 4 shall be necessitated. So, para. Today, when the matter is called, the learned counsel for the respondents, Ms. Livika, again please for some more time, as the respondent number 4,
The matter is pending before.
as the matter is still pending before the respondent number 4. So, this court has already noted that the instant COP 29/2023 was filed on 14/12/2023. Stop. 23, so 24, 25, 3 years. It is now 3 years since the instant application was filed, and the respondents are yet to comply with the direction of this court passed in WPC 355/2021. Stop. Accordingly, the respondents are granted another 6 weeks, 6 weeks time to comply with the direction of this court. And in the event that the compliance is not, compliance order is not issued before the next date, the respondent number 4 is directed to be present in person to explain the delay and to explain the willful disobedience of the direction of this court. Stop. List 6 weeks, after 6 weeks, give it date. 15, September 3rd, no, 3rd is a Wednesday, 7th September, okay. 8, okay, based on 8 September.
Keep your light.
Prohibition item 8.
Yes,
Since I didn't see the counsel for
yes,
the respondent,
they are not around and no mention is made.
yeah, I thought he will appear virtually, but I have not seen him.
Yes. Yes, Roger, I am appearing for item number 4.
Yes,
Oh, now it's item 8.
we are in item 8. We are in item
okay.
8.
Sorry, Roger.
Anybody for Mr. YP Gupta?
Actually, Lordship, on 8/6/2026, the matter was fixed on 15/6/2026 for hearing on the interim. But on 15/6, the respondent has filed the affidavit in opposition. So instead of hearing the matter piecemeal, so with the consent of the parties, the matter is fixed today for admission hearing.
Of the whole matter, of the main matter.
Yes, for admission hearing of Lordship. Because, so the interim prayer was not pressed. Instead, since the pleading is complete, so we have consented to fix the matter today for final disposal.
For final disposal.
Though the pleading is voluminous, Your Lordship, it's because I have annexed the prosecution complaint. Altogether, there are 299 accused. All these documents are there. And then order, PAO, provisional attachment order, because of that, otherwise the matter is not that. But unfortunately, since
They are not here and no mention is also made.
then
So then we will maybe grant the interim order then.
For final disposal, if the matter will be fixed on Thursday,
Okay, we can do that.
Thursday for final disposal, and then in the event
In the event they don't appear, then
then
the interim will be
yes,
granted on that day. Learned Counsel, Mr. T.B. Jamir is present for the petitioner. None appears for the respondents when the matter is called. Learned Counsel for the petitioner, T.B. Jamir. None appears for the respondents when the matter is called. Stop. Which was the last order?
Lordship, may kindly see the order dated 8/6.
8/6.
That was the order when the
Yes,
matter was fixed.
On 8/6/2026, this court had directed that the prayer for interim will be taken up for consideration on the next date. Stop. The matter was again listed on 15/6/2026. Stop. On 15/6/2026, the learned counsel for the petitioner prayed that they may be given some time.
No, no, liberty if necessary.
Okay, anyway, we'll say on 15/6/2026, the matter, the direction was given to list the matter on 14/7/2026 in the admission hearing column. In the admission hearing column.
Lordship, if I may just a little question, on 15/6/2026, the respondent has filed affidavit in opposition.
Okay. On 15/6/2026, the respondents filed their affidavit in opposition.
Yes.
And the petitioner was also given some time to file a reply to the same, if so advised. Stop. And thereafter, the matter was listed on 14/7/2026 in the admission.
Directed to be listed on today, 14/7. Today is 14/7.
And the matter was directed to be listed today in the admission hearing column.
Yes.
In the admission hearing column. Stop. However, the learned special PP is absent and no mention has also been made on his behalf. So, accordingly, list the matter on Thursday will be 16/7 for admission hearing. Stop. In the event that the respondents remain unrepresented, the prayer for interim order will be considered.
Lordship, this IA is filed for condemnation of delay for 134 days. Lordship.
What about notice?
Notice, everything is served, Your Lordship, and I've also filed my compliance affidavit, Your Lordship.
Fosiko, you're appearing for?
I'm for the claimants.
Claimant.
Yes. The claimants are 1 to 5.
1 to 5.
In respect to the delay, I have no objection.
How many days?
134 days, Your Lordship.
Okay, then we will condone it. Okay, this order will be in IA 164. The instant application under Section 5 of the Limitation Act has been filed by the appellants/applicants, praying for condonation of delay of 134 days in filing the connected MSc appeal against the
Judgment in order
where is that?
22/4/25, Your Lordship.
Have you stated in your this application
Yes, Your Lordship.
against the judgment dated 22/4/2025 passed in MSc case number 16 of 2024 by the learned MSCT Dimapur. Stop. Heard learned counsel for the applicant, Ms. Kim Penyu. Stop. The main reasons for the delay has been set out at paragraph 7 of the application. Stop. I have gone through the same and find that sufficient cause has been shown for the delay of 134 days. And accordingly, the delay of 134 days in filing the connected MSc appeal is condoned and the application is allowed. So, learned counsel, Mr. Fosiko Forte appears for the claimant respondents number 1 to 5 and has also not raised any objection regarding the delay. So, the application is accordingly allowed and disposed of. The registry it's already registered, no? The registry shall list the main MSc appeal for admission after 1 week.
Lordship, in respect of the other IA, that's for stay. That can also be
165.
interfered.
Okay, or we can admit the appeal. In the main appeal, you say, don't delete that last line, okay? Just say petition is allowed and disposed of. Then in MSc, MSc 18 of 2025, you say, what is your main ground for the appeal?
On page 6, Your Lordship. My grounds are in 3, there are 3, Your Lordship.
No post-mortem was conducted upon the deceased who was driving the vehicle. Okay. The instant appeal under section 173 of the MV Act has been preferred against the judgment and award dated 28/2/2025 passed by the learned MACT Dimapur in MSc case number 16 of 2024. So, heard learned counsel for the appellant, Ms. Kim Penyu. Stop. The main ground taken by the appellant herein is that the claim petition was filed under section 166 of the MV Act, and as such, the claimant/respondent had to prove rash and negligent driving by conclusive and concrete evidence. However, the same has not been proved by the claimant respondent in the before the tribunal. Stop. However, the learned tribunal failed to appreciate this aspect and has committed a grave error of law by passing the impugned judgment. Stop. Another ground which the appellant has taken is that no post-mortem was conducted upon the deceased who was driving the vehicle number, vehicle with registration number NL-05C 2698. Stop. Hence, it was not proved as to what was the cause of death of the deceased. Stop. Being aggrieved, the appellant has come before this court. So, admit the appeal, call for the records from the learned MSCT Dimapur. So, learned counsel Mr. Fosiko Forte has entered appearance on behalf of the claimant respondents number 1 to 5. Hence, no formal notice. You have received copy?
No, Lordship.
Hence, no formal notice is required. However, the learned counsel for the appellant shall supply extra copy of the appeal memo on the learned counsel for the respondent 1 to 5. So, the learned counsel for the petition appellant shall also take steps for service on the respondent 6 and 7 by registered post. No, sorry, by speed post as well as usual process within 3 working days from today. So, list after 4 weeks. Then in the stay application IA 165. This application has been filed by the appellant/applicant praying for stay of the impugned judgment and award dated 22/4/2025 passed by the learned MSCD Dimapur Nagaland in MSc case number 16 of 2025. Stop. Heard learned counsel for the appellant Ms. Kim Penyu. So, it is submitted by the learned counsel that the appellant/applicant has preferred an appeal against the impugned judgment dated 22/4/2025 in MSc case number 16 of 2024, and the same has been admitted by this court. So, it is submitted that the appellant has taken good grounds for appeal and which are likely to succeed, and therefore, if the impugned judgment and award is not stayed during the pendency of the appeal, irreparable loss will be caused to the appellant/applicant. Stop. Para. Learned Counsel, Mr. Fotico Fose appears on behalf of respondent number 1 to 5. Claimant respondents number 1 to 5. Stop. Para. Upon hearing the learned counsel for the appellant/applicant, this court is of the view that the impugned judgment and award needs to be stayed during the pendency of the appeal. Therefore, the impugned judgment dated 22/4/2025, passed in MEC case number 16 of 2024, shall remain suspended during the pendency of the appeal on subject to the condition that the applicant/appellant shall deposit 50% of the awarded amount before the registry of this court within 6 weeks from the date of this order.
Obliged, my
Uh,
lord.
Sorry for interruption, Lordship. I was waiting for item number 4, Lordship. It was mentioned in the morning, maybe.
Yes, already mentioned.
Okay,
It
Lordship.
was mentioned.
My presence may be reflected, Lordship, maybe.
Okay, item 4. Huh? You just put his name as present for the petitioner. Your name, Mr.
MJ Gogoi, Lordship.
M. Gogoi.
MJ Gogoi.
Yes.
And the date may be fixed, Lordship, if possible.
I think we have already fixed a date.
Okay, okay then. Obliged, Lordship.
May I please, Your Lordship? Lordship, by order dated 4/6/2026, I was directed to submit this to respondent number 1. And accordingly, on dated 8/6/2026, I have served copy to respondent number 1 through speed post.
Registry will have you serve through the registry.
Yes.
So I think tracking report is required.
It was intimated to me they have the respondent number 1 have already received a copy.
But they are not appearing today.
Yes.
So unless the tracking report is furnished, the court cannot deem serve, cannot pass an order that is deemed serve. Learned counsel for the petitioner, Mr. Mokuka, is present. So Learned PP, Mr. Thipapom, is present for the state respondents. Stop. Office note dated 9/6/2026 indicates that the notice upon respondent number 1 has been taken through speed post on 8/6/2026. Stop. The registry shall obtain the tracking report of the consignment and place the same before this court on the next date. Stop. List.
Lordship, may I interrupt? Is this item number 13?
This is
Yes. Item 13.
Item
13.
The order I've received instruction. Yes, I've received instruction for
Oh, okay,
respondent 1, Your Honor.
You delete regarding
Yes.
the.
Yes, Lordship. Lordship, I may be granted 3 weeks' time to file my affidavit as well as
Mr.
apply online.
Mr. Hetokal, Learned Counsel, enters appearance, submits that he has received instructions to appear on behalf of the respondent number 1 and prays for how much time?
3 weeks' time.
3 weeks' time to file his vakalatnama and to file the affidavit in opposition if so advised. Accordingly, list after 3 weeks. Yes.
Much obliged.
Obliged. Obliged.
May I please, Lordship?
Yes.
My Lord, I have instruction to appear on behalf of respondent number 1, my Lord. So kindly allow me 3 weeks' time to file my affidavit, and in the meantime, I'll be filing my Vakalan number.
Learned Counsel, Ms. Remboni is present for the petitioner. So, Mr. T. Papom, learned government advocate, submits that he has instructions to appear on behalf of respondent number one and prays for 3 weeks' time to file his Vaklatnama and to receive further instructions. So, list after 3 weeks is brief.
Much of it.
For orders, item 22.
Yes.
This your ladyship. Ladyship, I have instructions to appear for respondent number 2 and 3.
2 and 3, yes.
Yes, I may be allowed your ladyship 3 weeks time because that is the verbal instruction that I have received from the contemporary respondents.
This is for regularization, only for the pension benefit.
Yes, something.
Learned counsel, Ms. Such and Such is present for the petitioner. Stop. Mr. Moa Imchun is present for respondent number 2 and 3 and prays for 3 weeks' time to receive further instructions in the matter. Stop. You'll have to file an affidavit showing the steps taken by you, okay? List after 3 weeks as prayed for. Stop. On the next date, the respondent number 2 and 3 shall file the affidavit with regard to compliance of the order of this court dated 18/7/2025, passed in WPC 337/2022. So list after 3 weeks.
Your Lordship, if the matter may be listed for admission in the next day.
Now, whether it's for admission or orders, if it's complied, we'll close it. Yes.
From the supplementary process, orders item 23.
Please, Your Lordship.
Yes.
This contempt petition is filed against the writ petition, the order which was, the interim order which was passed in the writ petition number 42 of 2026. And the same writ petition was listed before the court one. We have submitted the, it may be kindly listed. We have prayed for listing, clubbing it together, so the lower court has allowed to list it before this court on Monday.
Oh, all together.
Together with this contempt and the writ petition.
Okay. So, the counsel for the parties are present. Stop. It is submitted by the learned counsel for the petitioner, Ms. Prohibitions, that the matter is to be listed along with similar matters, namely, do you know the numbers?
Yes, the WPC 42 of
WPC
2026.
42 of 2026.
This was filed for non-compliance of this interim order passed in WPC 42 of 2026.
Okay. To be placed along with WPC 42 of 2026. Stop. An order has been passed like that accordingly.
Yes.
And the when was this?
Today.
Oh, and the said order has been passed by the coordinate bench today, i.e. 14/7. So accordingly, list the matter in accordance. Yes.
In the meantime, I'll be filing my Vaklatnama on behalf of respondent number 3.
You have filed or you want to file?
I want to file.
Mr. Z. Kulno, learned counsel, also prays that he may be allowed to file his Vaklatnama on behalf of
Respondent number 3.
respondent number 3. So the prayer is allowed. The same shall be filed before the next date of listing. List on Monday. Oh, okay. List on 27 as directed. Yes.
Much obliged.
For hearing, item 19. Lordship, this make appeal is filed against the award and judgment passed by the learned in City Dimapur, Nagaland, dated 16/6/2025, Lordship. Lordship, the brief fact of the case is that on 25/11/2022 at about 8:30 p.m., the claimant was a pillion rider who was returning towards Lahore Region in a motorcycle CB Shine Gearing registration number NL07R 4585 from Saharijan Sukhajan site, Bokajan. After handing over the marriage gift, as was instructed by Sri Manik Majumdar, owner of the motorcycle, well on his way, and on reaching near Palangso Tinali.
All the parties are here. Okay.
On National Highway 39 under Bokajan subdivision, Karbi Along, Assam, at around 8:30 p.m., the motorcycle was ridden by the respondent number 3 in a rush and in a negligent manner, which was met with an accident. As a result, Lal Babu Mahanto, aged about 33 years, sustained grievous head injury, due to which the claimant has suffered permanent disability and there is less chance of recovery, while the rider, respondent number 3, sustained only minor injuries. After the accident, the claimant was brought to Bokajan CHC by the people around there. After attending first aid by doctor at Bokajan, he was referred to Nichols Hospital, Dimapur, Lordship. My main grounds is in page 6, Lordship. Paragraph 3, Lordship, if I may read.
Yes.
Further, the learned tribunal failed to observe that the claimant only produced a to whom it may concern certificate, which was exhibited as PW 14 1 to 4 in their claim petition, purported to have been issued by the opposite number 1, claiming the claimant to be labor in charge. However, the same has not been written on an official writing pad bearing either trade license number, registration number, contract license number, address, etc. And neither any appointment letter nor any attendance sheet or employee list or salary records or pay slip were placed on record by the DW number 1 or the claimant as to corroborate their claims as to the employment and earning of rupees 18,000. Therefore, in the absence of any definite proof of income or any corroborative documentary evidence of the same, the Honorable Tribunal should have determined the salary of the basis of national income minimum wages for an unskilled labor, as the claimant was the labor in charge, whose duty was only to arrange the labor and see the progress of the work. Thus, without any valid or proper documents, the tribunal has decided that the claimant was earning 18,000 per month, which needs to be challenged in this instant case. Your Lordship, I have annexed the to whom it may concern as my annexure B in page 29, Your Lordship. My next ground is in paragraph 4, Your Lordship, page 7, Your Lordship, if I may, Your Lordship.
Then?
Page 7, Your Lordship, paragraph 4, Your Lordship. For that, the learned tribunal has failed to observe that the officials issuing the disability certificate has not been examined. In this connection, it is stated that in Sudhir Buyan versus National Insurance Company Ltd and another 2005 SCJ 509, it was observed as under If the appellant really wants to support from the opinion of any doctor or board of doctors, the insurance company and the owner of vehicle against whom the said opinion will be used should be given an opportunity to cross-examine those persons for the purpose of ascertaining the truth of their opinion contained in the certificate. It is preposterous to suggest that by mere producing a certificate showing that a person has become disabled, he can force the insurance company or the owner of the vehicle to pay compensation, though the genuineness of the documents is not proved and they are not in a position to cross-examine the person who has allegedly given such opinion. Hence, the disability certificate was not proved by giving opposite parties opportunity for cross-examination of the doctors who issued such disability certificate, which needs to be challenged in the instant case. Lordship, in addition to my submission, if I may be allowed to cite some case laws, Your Lordship. SCC 2011, Your Lordship. Raj Kumar versus Ajay Kumar and another, Your Lordship. Para 12, Your Lordship. If I may, Your Lordship. Therefore, the tribunal has to first decide whether there is any permanent disability, and if so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence whether the disablement is permanent or temporary. If the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. If the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functions of the entire body, that is, the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. But if the tribunal concludes that there is a permanent disability, then it will proceed to ascertain its extent after the tribunal ascertains the actual extent of permanent disability of the claimant based on the medical evidence. It has to be determined whether such permanent disability has affected or will affect his earning capacity.
So you're saying that doctor was not examined?
Yes, Your Lordship. I will also like to cite one more case laws, Your Lordship. 2010 to GLT, Your Lordship. Para 10, Your Lordship. If I may, Your Lordship. The learned counsel for the appellant pointed out that the learned tribunal relied on the disability certificate to conclude claimant permanent disability of 55% without examining the doctor who had evaluated and issued the certificate of disability to the claimant. Learned counsel further contended that the certificate purport to be issued by the medical board of JMP bore the signature of the doctors working in civil hospital ISO. As a matter of para 11, as a matter of facts, in assessment of percentage of disability of an injured, a medical expert in the field plays a crucial role. On the basis of such assessment, a tribunal embarks on evaluating the loss of earning capacity triggered by the disability of the claimant. The degree of disability and loss of earning capacity are not synonymous, loss of earning capacity cannot be assessed by resorting to mere guesswork. The tribunal should, for all practical purposes, take assistance of a qualified medical practitioner to assess the extent of permanent disability of the claimant. On the other hand, non-examination of the doctor as a witness who gave the certificate of disability would deprive the insurance company to test the veracity and or of the truthfulness of the statement and correctness of the document placed on record by the claimant before the tribunal. The tribunal is required to assess the loss of earning capacity, keeping in view the percentage of the disability suffered by the claimant. So, Your Lordship, if I may cite one more case loss, 2001 GLT, Your Lordship, National Insurance versus Chandeswar Thakur and others, Your Lordship. Para 2, Your Lordship, if I may read.
Which one? 2001.
Yes. Your
1
Lordship.
GLT.
Yes.
Para
2, Your Lordship. If I may read, Your Lordship. The whole contention of the appellate is that the learned tribunal arrived at the conclusion that the claimant suffered permanent disability without examining the doctor, since the claimant suffered a sustained injury. It was incumbent on the part of the claimant to have examined the doctor and established its case as to what percentage of permanent disability was suffered by the claimant. It would clearly appear that besides submitting a certificate from the doctor, no doctor who has treated the claimant have been examined by the claimant. Non-examination of the doctor to establish the extent of disabilities suffered by the claimant denied the opportunity to the insurance company to cross-examine the doctor. In our jurisprudence, witnesses put up by either of the parties is subject to cross-examination, so as to test veracity or the truthful or correctness of the statement of the witnesses. In the instant case, no doctor has been examined to establish the extent of disability suffered by the claimant, and in that view, the permanent disability has not been proved. Apart from that, the tribunal settled the liability with the insurance company on the compensation assessed on the basis of permanent disability suffered by the claimant, without giving any opportunity to of cross-examination, examining the doctor, Your Lordship.
yes,
Yes.
then
Coming to my next drawing, page 8, Your Lordship, para 5, Your Lordship. If I may, Your Lordship.
yes.
For that, the learned tribunal failed to observe that the insurance policy number 132-000/31/2023/1900 issued to Manik Mazumdar for vehicle number NL07R4585 is motorized two-wheeler package policy meant for private purpose only, hence cannot be used for commercial purpose, such as in the present case. As per cross-examination, it is mentioned that the injured Lal Babu Mohanto was employed and working under the insurer Manik Mazumdar. As policy was issued for private purpose, no question of premium for paid drivers, handyman, etc. is available for two-wheelers policy in case if the injured owner authorized such person to drive and the use motorcycle, then he cannot be considered as third party but step into the shoe as owner of the motorcycle, which needs to be challenged in the instant appeal. Your Lordship, I've annexed the insurance policy as my annexure C in page 30, Your Lordship, 30 and 31, Your Lordship. Lordship, as in page number 31, which I've annexed, here in the important notice, it has been stated that the insured is not indemnified if the vehicle is used or driven otherwise than in accordance with the schedule, Lordship. Any payment
Where is that? Where is that? Page 31.
31, yes. Just a little bit below the
yes,
important
yes.
notice, yes, Lordship. The insured is not indemnified if the vehicle is used or driven otherwise than in accordance with the schedule. Any payment made by the company by reason of wider terms appearing in the certificate in order to comply with the MV Act 1988 is recoverable from the insured, Your Lordship.
Own damage, liability, basic cover. Use only for social, domestic, and commercial business. The deceased was the pillion rider,
Yes, Your Lordship.
and who was driving?
He
The-
was also the employee of the insured person, Your Lordship. He was,
No. If the deceased was a pillion rider,
yes.
who was driving? The owner himself.
No, Your Lordship. He was the respondent number 3 who was riding. And he is also working under the insured person, Your Lordship, as an employee.
Okay.
Yes.
Respondent number 3 was the driver, and the deceased was the pillion rider.
Yes, Your Lordship.
And respondent 2 is the owner.
Yes, Your Lordship. Lordship, coming to my next ground, Your Lordship, page 8, para 6, Your Lordship. If I may, Your Lordship.
1 minute.
For that,
Yes. Next.
my next ground is in para 6, page 8, Your Lordship. If I may, Your Lordship. For that, the learned tribunal calculated the compensation under the various heads is excessive and unconnected. In this regard, apart from the disputed question as to income, other expenses awarded are as follows: medical, nursing, special diet, etc., both present and future, rupees 15 lakhs, special aid on treatment, rupees 2 lakhs, damage for mental and physical shock, pain, suffering, etc., rupees 2 lakhs, damages for inconveniences, hardship, frustration in life, rupees 2 lakhs, and damages for loss of expectation of normal life due to accident, 2 lakhs, Your Lordship. In addition to this ground, Your Lordship, if I may cite one case loss, Your Lordship.
Yes.
2009 2009 6 SCC, Your Lordship. Smriti Sharla Verma and other versus Delhi Transport Corporation and another, Your Lordship.
What do you want to show from here, Sarla Verma?
Your Lordship, here in this case, as per to calculate the other future prospects and the calculation of the money, Your Lordship, is related to that.
You're saying that it was against the principle in Sarla Verma?
Yes, Your Lordship, since it is being calculated in excessively.
Special diet 15,000, treatment 2,000, 2 lakhs, mental shock 2 lakhs.
Para 9, Your
Yes.
Lordship.
Yes.
If I may, Your Lordship. Basically, on 3 facts need to be established by the claimant for assessing compensation in the case of the age of the deceased, income of the deceased, and the number of dependents. The issuing to determine by the tribunal to arrive at the loss of dependency are addition, deduction to be made for arriving at the income, the deduction to be made towards the personal living expenses of the deceased, and 3, the multiplier to be applied with reference of the age of the deceased. If this determines are standardized, there will be uniformity and consistency in the decision. There will lesser need for detailed evidence. It is also be easier for the insurance company to settle accident claim without delay, to have uniformity and consistency. Tribunal should determine compensation in case of death by the following well-settled step. Step 1. Ascertaining the multiplicand. The income of the deceased per annum should be determined.
No, but this is death case or injury? Injury, isn't it?
Yes, Your Lordship.
Injury. Yes. Yes, continue.
The income of the deceased per annum should be determined out of the said income, and deduction should be made in regard to the amount which the deceased would have spent on himself by way of personal and living expenses. The balance which is considered to be the contribution to the dependent family considered the multiplicand. Step 2. Ascertaining the multiplier having regard to the age of the deceased and period of active career, the appropriate multiplier should be selected. This does not mean ascertaining the number of years he would have lived or worked, but for the accident, having regard to several imponderable.
This is for death case.
So, Lordship.
This pertains to death, multiplier and all that. Okay. Basically, those three points. One is no proper salary certificate. Second is disability certificate not proved. Then vehicle was only for private use, not for hire or commercial purpose. Then excessive award.
It is humbly prayer that your Lordship may be pleased to admit this appeal, Your Lordship.
Award was 57 lakhs 56,000. Loss of income. Okay. Yes, that's all.
Yes, Your Lordship.
May I please, Your Lordship?
Yes.
The first objection of my learned friend is in regards to salary certificate.
Salary certificate. Hmm.
Lordship, here in this case, the certificate was signed, although it was written in a plain paper, it doesn't mean that it should be a paid. More so, Your Honor, the DW, the vehicle owner, that is DW1, has appeared before the Honorable Tribunal below and has laid his evidence. And
He appeared as DW1.
DW1, yes. Lord, Lordship, the insurance company, that is the, by that time, opposite party number 1, 3 and 4, they have cross-examined. In the cross-examination, they have never crossed as to why the certificate was given in a plain paper, as to why it was not written this license number, this and that. So let me read the cross did by the insurance company. Number 1, it is correct to state that I am the owner of the motorcycle bearing registration number NL07R4585. It is to state that on 25/11/2022, the accident took place near Sukanjan at about 12 midnight. It is to state that the accident occurred as the motorcycle skidded on the road. It is to state that the claimant, that is the pillion rider, received grievous injuries due to the accident. It is to state that by occupation, I am a businessman. Of course, English it is not clear here. It is to state that since I could not attend the marriage due to some urgent work, I had entrusted the rider and the pillion rider on my behalf. It is to state that the claimant is the labor in charge of the contract and was earning a monthly salary of rupees 18,000 per month. It is to state that the motorcycle to which the accident occurred is used for both personal and official use. It is to state that the motorcycle was having valid insurance policy at the time of the accident. Lordship, here, the DW2, the vehicle owner, he has given the salary certificate. He has also appeared before the learned tribunal below and has deposed his statement. And nowhere in the in cross-examination, the insurance company has such type of put such questions. So hence, the salary certificate issued by the vehicle owner stands.
Okay.
Secondly, the other objection was in regards to disability certificate.
Disability certificate.
Yes. Lordship, here in this case, the respondent, that is Lal Babu Mohoto, he is grievously injured. Even I have seen the insurance council, they have seen, because we have taken the statement on commission. Even he cannot stand up, he cannot even speak. This is the situation. And moreover, the photographs are also placed by the commissioner, advocate commissioners in the case report. And he was examined by the medical board, Dibu Medical College, and he was given 90% disability. And as per the procedure that is done in Assam, this certificate is sent to the social welfare officers. And thereafter, this certificate is issued.
Where is the certificate? It's not annexed in the petition.
Yes,
no?
in their appeal memo they have not annexed, but I have annexed.
It's from a government board.
Government board. It is exhibit PW 110.
Can you just mark it? Just put a tag, okay? Give it to him. You just tag the salary certificate also in the records, and then you flag it. Flag the salary certificate, you flag the disability certificate.
Yes.
So that it will be easier for the court to go through.
Exhibit PW 110.
PW
110.
110. So the board has also given 100% disability.
90% loss.
90%. Then how the tribunal gave 100%?
Lordship, when a person is 90% disabled, when he cannot walk up, when he cannot even speak, he is 100% disabled in respect, in regards to function.
Totally disabled.
Totally, Lordship. Lordship, after the judgment is over, delivered by the tribunal below, the claimant's relative has also handed over his unique disability ID, Government of India.
Yes.
Lordship, in this regard, I would like to refer one case that is same as referred by the learned friend, that is Rajkumar versus Ajay Kumar, para 23.
No, but Rajkumar, Ajay Kumar, it says that doctor has to be examined.
No, Lordship, there is option also. So let me go through. Para 23. The tribunal should realize that a busy surgeon may be able to save 10 lives or perform 20 surgeries in the time he spends to attend the tribunal to give evidence in one accident case. Many busy surgeons refuse to treat medical legal cases out of apprehension that their practice and their current patients will suffer. If they have to spend their days in tribunals giving evidence about past patients, the solution does not lie in forcing the doctors to attend the tribunal to give evidence. The solution lies in recognizing the valuable time of the doctors and accommodating them. Firstly, efforts should be made to record the evidence of the treating doctors on commission after ascertaining their convenient timing. Secondly, if the doctors attend the tribunal for giving evidence, their evidence may be recorded without delay, ensuring that they are not required to wait. Thirdly, the doctors may be given specific time for attending the tribunal for giving evidence instead of requiring them to come at 10:30 a.m. or 11 a.m. and wait in the court hall. Fourthly, in case where the certificates are not contested by Lordship, are not contested by the respondents, they may be marked by consent, thereby dispensing with the oral evidence. These small measures, as also any other suitable steps taken to ensure the availability of expert evidence, will ensure assessment of just compensation and will go a long way in demonstrating the court's tribunal show concern for litigants and witnesses.
They have not disputed.
Yes, Lordship. At the time when the documents were exhibited, they did not protest. When they did not protest means it is documents were exhibited with their consent.
Yes, then?
Then Lordship, the other, my learned friend,
the other one is regarding the policy condition.
The vehicle was used for commercial purpose, this and that. The Lordship here, of course, in the cross-examination, in what way he has said, that is not known. But at the time of accident, whether it was used as for commercial purpose, that has to be gone through. At the time of accident, it was not used for commercial purpose. Both the rider and the pillion riders, of course, as admitted, were the employee of the respondent.
That respondent
too. So they were sent to for giving one marriage gift, as he was going outside like that. So, Lordship, to prove the commercial purpose, it is that the vehicle was used with fare.
By paying fare.
By paying fare. But this is not the case here, Lordship. For the work of the employer, as requested, they were sent. So the question of, in this case, question of commercial use does not arise. He might have used sometimes back that is different things. I don't know. But here, at the time of accident, when the bike was handed over to them, they went. It is not that the rider and the pillion rider, they have paid the employer and have taken the bike. It is not the case. So question of commercial use does not arise here also.
They had gone for an errand for the owner.
For the work of the owner.
For the owner.
Yes, Lordship. So, Lordship, here my Latin friend has submitted that the injured has entered into the shoe of the owner. It is not the case, Lordship, here. The motorcycle is covered by package policy. First party.
It is a package policy.
Package policy, Lordship. And moreover, the injured person who was sitting as pillion rider and he was not riding. Had he been riding, that would be different.
It was written by the other.
Yes,
other
Lordship.
driver.
So there is no dispute when someone is a pillion rider in someone's bike, he or she is entitled to get compensation from the insurance company, Lordship. And this has been decided by the Katina out cases. Lordship, for the just
the respondent number, who was the driver? Respondent number 3.
Yes.
No. Respondent number 2.
Bhim Mahato. So
the owner was not driving.
Owner was not
driving. It was
that can be done, Lordship. Someone can give send his employee to some other place. That is not restricted in the policy. That is not a violation of policy terms and conditions, Lordship. So, being the motorcycle covered by package policy, the pillion rider is covered. So, Lordship, here I just want to refer the introduction part of the Supreme Court case. It is reflected in 2005, Volume 2, TSC 297.
which case?
TSC 2005, Volume 2, TSC. Page 297. This is of Supreme Court case, Lordship. Here I don't want to go inside, just introduction part. I may be allowed to do yes, because whether the pillion rider is covered or not, to that part only, Lordship. New India Insurance Company Limited, hereinafter referred to as the insurer, calls in the question legality of the judgment rendered by the Division Bench of the Kerala High Court, holding that the appellant was liable to pay compensation to the respondent number 1 for the injuries sustained by him in an automobile accident. The accident took place on 14 December 1997 at about 3:10 a.m. It was claimed by the claimant that that he sustained injuries because of the rash and negligence driving of the vehicle motorcycle The motorcycle bearing registration number this and this covered by driven by the respondent number 2. The claimant stand was that he was traveling as a pillion rider. A pillion rider. And now the other parts is in regards to compensation. So in this case, the Honorable Supreme Court has awarded the compensation. So just to highlight that whether the pillion rider is covered or not in a package provision.
If I may give one submission.
Let him complete first. Yes.
Now the last part, my learned friend has submitted, that is exorbitant compensation was granted to the
Against the head of special aid damages and all that, expectation of normal life. No, but then if this court upholds that 100% disability, then this is fine. If the court holds that 100% disability is correctly drawn by the tribunal, then in that case 2 lakhs for hardship, frustration, 2 lakhs for mental shock, this is reasonable.
Lordship, it is less. The only mistake is that I could not file the process. Lordship, again I want to refer this same case, Rajkumar versus Ajay Kumar. That is para 20. Lordship, here in this case, my learned friend has submitted that the awarded was exorbitant. But in this case, since the injured is badly injured and the medical board has certified that he is 90%, and to that effect even the government of India has also issued certificate stating that the respondent is 90% disabled. And in this case, Lordship, here in para 20, but in this case, Lordship, even the tribunal below did not grant future prospect.
Future prospect.
Yes, in such case, future prospect has to be granted, Lordship. So, some illustration were given in this case, Lordship.
But you have not filed the counter.
Lordship, that is different. Although that is, I have already admitted before this Honorable. That is the biggest mistake I have made. So, if the Honorable Court allows, I may read the illustration. Because this is the guide. Even this Honorable Court has ample power to enhance the compensation if satisfied.
Let's see. Para 20.
Para 20. The assessment of loss of future earning is explained below with reference to the following illustration. These are only examples, Lordship. Illustration A. The injured workman was aged 30 years and earning 3,000 per month at the time of the accident. As per doctor evidence, the permanent disability of the limb as consequence to the injury was 60% and the consequential permanent disability to the person was quantified at 30%. The loss of the earning capacity is, however, assessed by the tribunal at 15% and on the basis of the evidence. However, because the claimant is continued in employment, as because he was continued in employment, but in the lower grade. Calculation of compensation should be as follows. Annual income before the accident, it was 36,000, loss of future earning per annum, 15% per annum, annual income 5,400, multiplier applicable with reference to age. Since he was 30 years, multiplier of 17 was taken. Loss of future earning. Now, this 5,400 into 17, here comes 91,800. This is just an illustration given by the Honorable Supreme Court. The second illustration B, the injured was a driver aged 30 years, earning 3,000 per month. His hand is amputated and his permanent disability is assessed at 60%. He was terminated from the job as he could no longer drive. His chance of getting any other employment was bleak, and even if he got any job, the salary was likely to be pittance. The tribunal therefore assesses his loss of future earning capacity as 75%. Calculation of compensation will be as follows. Annual income prior to the accident 36,000, loss of future income per annum 75% of the prior annual income, that is 27,000, multiplier applicable with reference to age 17, and the loss of earning 27,000 into 17 equal to 4,90,000. Illustration C is also given. The injured was 25 years and a final year engineering student. As a result of the accident, he was in coma for 2 months. His right hand was amputated and his vision was affected. The permanent disability was assessed as 70%, as the injured was incapacitated to pursue his chosen career, and as he required the assistance of the servant throughout his life. The loss of future income, future earning capacity was also assessed as 70%. The calculation of compensation will be as follows. Minimum income, annual income he would have got if he had been employed as an engineer, 60,000. Loss of earning, future earning per annum, 70% of the expected annual income, 42,000, multiplier applicable 25 years, 18. Loss of future income 42,000 into 18, that is 7,56,000. So in this way, the
Loss of future earning was not given.
Yes, loss. Hello. Lordship, this judgment is obtained online. So, Lordship, I want to refer para 11.
Yes.
Coming to the grant of compensation towards attendance charges, the claims tribunal was of the view that an amount of rupees 6 lakhs could be granted under the said head. The High Court, however, was pleased to reduce the aforesaid amount to rupees 3 lakhs by observing that rupees 6 lakhs appeared to be excessive. In our view, the claimant, having suffered permanent physical disability to the extent of 100%, he would definitely require assistance during his further life. It has come to the evidence of the claimant that he was required to use a water bed for his comfort, considering his handicap. He was also required to use a wheelchair, even for attending nature's call. On that basis, an amount of rupees 2,000 per month for a period of 25 years came to be awarded. In our view, again considering the nature of the disability suffered by the claimant, he would require the services of an attendant for the rest of his life. The claimant being aged only 21 years when the accident took place, a lump sum of rupees 10 lakhs towards attendant charges for the rest of his life would meet the end of justice. As noted above, if the claimant invests part of the amount of compensation, he would receive interest on such invested amount that would take care of the future expenses under this head. Accordingly, an amount of rupees 10 lakh is granted towards attendance charges. Whereas in this case, the Honorable Tribunal has awarded only 2 lakhs, and
How old was the claimant?
he was 32 years. Lordship, he was for more than 3 months in ICU in Faith Hospital. Even now, Lordship, he cannot, he is surviving due to liquid food. A hole is made here.
Tube feeding.
He half dead, half alive.
33 years. Okay.
Lordship, again, I want to refer 2016 Volume 1 TAC 237 Hyderabad, full bench. Para 1, Lordship, I may be allowed to read. I quote: the first division bench in PD Gala, Linga Reddy, and others, and Satla took a view that the court cannot grant compensation exceeding the claim amount subject to payment of court fees, if any, payable. Another division bench of this court in New India Insurance Company Limited versus Chintanala,
Took exactly.
2002 Volume 3 ALT, this Lordship took exactly the opposite view, holding that the tribunal court is not empowered to award higher compensation than the compensation claimed by the claimant. The order of reference was made on 28th June 2022. Para 2. Thereafter, the same question fell for consideration of Supreme Court in Nagapa versus Guru Dayal Singh and others. 2003, Volume 2, SCC 274. And the question was answered in the affirmative, holding that the Motor Vehicles Act 1988, there is no restriction that the compensation could be awarded only up to the amount claimed by the claimant. In appropriate cases, wherefrom the evidence brought on the report, if the tribunal court considers that the claimant is entitled to get more compensation than claimed, the tribunal may pass such award. The only embargo is it should be just compensation, that is to say, it should be neither arbitrary, fanciful, or unjustifiable from the evidence. Such observations were made in the light of the provision contained in section 166A and 4, 158 clause 6 and 168 of the Motor Vehicle Act 1988. This view was thereafter reiterated by the Supreme Court in Rajesh and others versus Rajbir Singh and others, 2013, volume 9, SCC 54, Sanjay Verma and Haryana Roadways, and Jitendra Khimsakar, Trivedi and others versus Kasam Daud Kumbhar and others, 2015, volume 4, SCC 237. Thus, in the view of the above law laid down by the Supreme Court in the aforementioned judgment, the question referred to the larger bench must be answered in affirmative. Accordingly, the law declared by the division bench in Chintamala case accordingly stands overruled. So, if the Honorable Tribunal or any appellate court can
Yes,
grant,
yes, of course. It can go beyond also.
And Your Lordship, I have forgot to cite one case in regards to salary. So I may be allowed. Para 16. In the case of B. Patmabhati versus Bharati Axa General Insurance Company Limited. Para 16. I may be allowed to read, Lordship.
1 minute.
I quote, in the present case, the MACT proceeded on the premise that the monthly income of the victim was rupees 6,000. This was consequently enhanced by the High Court to rupees 7,000 ALB without recording any reason. However, Learned Counsel appearing for the claimants has rightly drawn our attention to the salary certificate issued by the employer of the victims, marked as Exhibit P14, which univocally records that the victim was employed as a driver on a fixed monthly salary of rupees 10,000. This documentary evidence is further corroborated by the affidavit shown by the victim's employer, PW3. On the face of such cogent and relevant evidence, which was not impressed by the insurer, it would be wholly impossible to assess the income at a lower figure. The determination of income must be founded on proof of place on record and cannot rest on conjecture or assumptions divorced from evidence. According to the purpose of recomputation, the monthly income of the victim has to be reckoned as rupees 10,000. So, Lordship, here in this case also, firstly, he has issued the salary certificate. Secondly, he has appeared before the tribunal, and on oath, he has deposed that the claimant was his employee, and he was paid a monthly salary of rupees 18,000.
Okay. Yes. Yes, you wanted to say something?
Yes, Your Lordship. Your Lordship, the policy is a package policy, Your Lordship, and also that as at next in my annexure C, page 30 and 31, in the page 31, it have also scheduled as premium, Lordship, on damage, Your Lordship, and also the important notice which I've read out before, Your Lordship. Which clearly states that
No, but where it cannot be proved that it was used for commercial purpose. No, it was for private purpose only. It was used.
yes, Your Lordship.
It was the owner who had sent them. And the claimant was the pillion rider. He was not the driver of the motorcycle. Plus, it was not the owner who was driving also. Yes, then anything else?
That's all, Your Lordship.
Heard Tribunal Counsel, Ms. King Penny for the appellant. I've also heard Mr. P.P. Chetri for the respondent number, payment respondent number 1.
Lordship.
Payment respondent number 1. Hearing is concluded. Order reserved. Once it's okay, put it in the file.
Obliged.
Yes. And send it to the chamber.
Pero